of the preamble.
What's the status of the rules, if you will,
The preamble
today
has
as
been-
we speak?
Good question. Last Monday, in an open meeting, they modified the preamble, and they took out all the parts that are controversial. Now it basically says, we welcome your comments, please keep them germane and relevant, and you have 3 minutes. It's at number 78 in Mr. Sullivan's declaration. Let me read it to you so that it's in the record. So it says, this is an optional time period dedicated to listening to the public. We want to hear your ideas or concerns. To ensure equal opportunity for the public to comment, all comments shall be limited to 3 minutes, and each person may address the board 1 time. And then it talks about the green light, the process for knowing when you run out of time. There's a green light, a yellow light, and a red light. So it's very neutral right now. The status right now, until this case is cleared up, until we understand the parameters of what is or is not constitutional, is that all the language that Mr. Belenski has complained about is no longer there. Because we understand that we're under a possibility of an injunction, and it's always possible that even if Mr. Belenski does not obtain his injunction, that at a bench trial down the road, constitutional violations could be found. Thank you, Your Honor.
Thank you very much, Mr. Alvarez. Mr. Belenski, you reserve 5 minutes. Incidentally, Madam Clerk, if our call comes in, we're still in argument, would you have them call back, say in 15 minutes if they can? Go ahead.
I'll try to make it brief. I'm Chesterfield County. I don't know what county that's in, so I don't know what state that is, but I don't know what their state constitution says about being able to speak, but ours says we can speak freely about whatever we feel like speaking about, and we're held accountable for what we say. I think if you look at, I think it's cited in my brief, Baca versus Reno Valley Unified School District. It's Southern District of California, so that'd be the 9th Circuit. I think that, I mean, it's not a 9th Circuit case, but it's a federal case in that would be in that circuit. So I would think that would trump whatever happens to be in Chesterfield County if that's not in the 9th Circuit. In my second declaration, I specifically explained that, like Larry Carter, he was not able to mention the name of George Yount, but when Mr. Yount got up to speak, he was allowed to mention the name Larry Carter. He was allowed to mention the name Robert Thorpe. He was allowed to mention the name Olympic Stewardship Foundation, which I'm a member of. He was able to name the Pacific Legal Foundation, Kitsap County Association of Property Rights. He had carte blanche to mention whoever he wanted. And when Mr. Fritz tried to mention colleges from Port Townsend on November 9th, he gets shut down because he's not allowed to talk about groups of individuals. So whatever the preamble said that day, on either of those days, it had no effect because people were able to talk about whatever they wanted as long as the identity of the speaker was acceptable to Mr. Sullivan, along with the content and the viewpoint of the person's message. They talk about alternative forms. Mr. D'Amico has sent letters or sent emails to Mr. Sullivan. And in his second declaration, which he attaches those emails, Mr. Sullivan deleted them without even reading them. So the fact that there's an alternative form, I think it's more appropriate that a person be able to speak and talk where others can hear them, rather than send an email that the person will not even bother to take a look at and read. I'd rather stand in front of the person and make sure that they hear that message rather than deleting it without reading it. I think the county's missing the point. The point here is that my litigation is not related to time, manner, place, because that's for the court to decide what form exactly it is that we're speaking about when it comes to county commissioner meetings. My argument is that I have not spoken since November 9th because I'm not going to be subjected to arbitrarily and capricious, unbridled discretion of Commissioner Sullivan based on the content of my message, the viewpoint of my speech. I'm not gonna ask permission, I'm not giving him prior restraint, he's not gonna censor my message. And I'm entitled to equal protection and due process under the law, the same as Mr. Yount and any other speaker that comes before Commissioner Sullivan. And my argument is that the rules are not applied equally. And I think the declarations I turned in prove that, and I think I prove that I will suffer irreparable harm because I do not know where the parameters are between lawful and unlawful speech at a county commissioners meeting. And I think it's clear in my brief.
Well, that's the question of this whole lawsuit.
Well,
Where is the line?
well, I'll close with this then. In my brief, I say, Article 1, Section 5, and I also cite Collier versus City of Tacoma. If the state wants, if the Board of County Commissioners wants to restrict, prohibit, censor, prior restraint my speech, the burden is on them to prove that they have the right to prohibit my speech, and they haven't done that. So I think the injunction should issue so that myself and every other person knows that they have the right to come into a county commissioner meeting and speak their mind. I'm not arguing that they don't have the right to remove people that are disruptive. I'm not arguing the point that, you couldn't, if you slander somebody that you couldn't get sued for it. My point is, whatever my message happens to be, you don't interfere with it. If I step over the line, then they need to take action against me. They have no right to influence or prohibit or censor what I say.
All right. Well, it may be at some point in time that some kind of injunctive relief will be granted. It's not going to be today. The reason it's not going to be today is because the element of irreparable immediate harm or substantial damage that would occur if I did not grant an immediate injunction has not been shown. I make no judgment whatsoever on the merits of your case, Mr. Belenski. We're just dealing today with whether or not an immediate emergency injunction is appropriate, and it is not under these circumstances. The matter needs to be set for trial, and it will be heard on its merits unless it can be resolved by motion, and I'll leave that up to the parties. But the injunction will not issue today. Either party have an appropriate order to present?
I do, Your Honor.
And Mr. Belenski, for what it's worth, whether you saw the things that were sent to the court this week or not, they have no bearing on my ruling today. My ruling would have been made had they not responded at all, because I know the law of temporary injunctions. And that's a very limited reason you're not getting your injunction today, but it's a very important one.
Okay.
We're not going to have the neighbor's trees clear cut if an injunction wasn't issued.
Okay.